Time now for Ask the Expert on CTV Morning Live, and we're talking with O.J. Hollingsworth today, personal injury lawyers. We have Brenda Hollingsworth with us today, personal injury lawyer. Good morning, Brenda. Great to have you along.
Good morning. Yeah, nice to be here.
We're going to run through some scenarios that are probably all too common for your practice, and we'll run through how someone would handle them and what the outcomes could be. Let's start with scenario number one. You had a serious car accident where the car behind you hit you at 60 kilometers an hour. You were stopped at a stoplight. It's obvious to you that the other driver must have been texting. The police arrive and the other driver gets a ticket, but not for distracted driving. This really bugs you because he must have been texting. What should you do, and will it hurt your case? Let's start at the point where, do you have to have proof that they were texting? Because sometimes we can see someone's head is down, but maybe that wasn't always the case. Do you know for sure?
Well, that's the whole thing, right? Unless you have someone who saw the person texting, you're going to have a really hard time proving distracted drivers. And police officers know that, right? Of course, they're trained. They know what can be proven and what can't. So nobody admits they were texting. And so typically it's a charge. If they get charged, it's going to be following too closely, something like that. And, they'll get a ticket, but it won't be what you want. People really want distracted driving tickets, but in my experience, they're very rare.
So obviously a distracted driving charge is more serious, assuming, than following too closely. So, one would assume that your case may be impacted differently if you decide to sue.
Yeah, and that is a misconception. So once someone is negligent, they're negligent. So you don't get more if the behavior of the other driver is worse. So all you have to prove is negligence, and following too closely, ramming into the back of a stopped car, that's negligence. And so it's fine that that's all that can be established. You don't have to prove more, and your case will not suffer.
That's interesting. I don't know that we've talked about that as much before, because that really shows that exactly that. Somebody might be kind of after the police officer on the scene. Well, why aren't you charging them with more? Why aren't you charging them with more? If they're even thinking that far ahead, that they would sue or that they would seek compensation. So negligence then is pretty broad in a way.
It is. If you don't meet the standard of a reasonable driver, you're going to be negligent. And there are no degrees of negligence, at least not in car accident cases. And so at the scene, people don't typically know what the other driver was charged with. It's later on, like a couple weeks later, they find out what the ticket was. And we've had clients who the first reason they call us is because they're mad at the police officer, and they want us to fix it. That's just not necessary.
Do they still have a case in that regard? If there's negligence, what kind of a case does that look like?
Yeah, no, they hitting someone from behind, you're almost always responsible. In Ontario, even if the car in front of you stops suddenly, you're still going to be responsible for the rear end accident. And so getting fixated on distracted driving, I raise this because it's very, very common that people are upset that there's no texting related comments in the police notes or ticket, and the case doesn't become about distracted driving. People get very upset about it, but you got to keep your eye on what's important, and what's important is proving negligence. And if somebody hits you from behind, you're going to be able to do that.
Let me ask you this. You said someone has to witness the texting, and even then, it's still up to the police officer at the end of the day. If you do witness the person texting and they hit you, and you become a witness to that to the police officer, does the charge change then, or not so much?
Police officer has discretion, right? They're always, they have a criteria that they have to follow to determine, whether or not they're satisfied that a charge is going to stick. And in the moment, they make the best decision that they can. If you've been badly injured and you're shaken up, the police officer is going to assess how reliable your evidence, not only whether or not the police officer believes you, but how reliable your evidence might be at court. And maybe the best thing to do is to charge the driver with something that will stick.
So I guess the best takeaway from this example is negligence. No matter the charge, you will have a case. Okay, let's move on to another question. I appreciate that one. You injured your shoulder in a motorcycle accident. Your rotator cuff is torn and you'll probably need surgery in the next few months. 10 years ago, you had a separated shoulder on the same side due to a hockey injury. Will the previous injury to the same shoulder make a difference to the amount of compensation that you receive?
Right. Pre-existing conditions. That is something that people worry about a lot. And really, pre-existing conditions are relevant, but they don't always hurt your case. Sometimes they help your case. Because sometimes you have an accident that, let's say causes a serious shoulder injury, but the accident itself isn't that serious. And the insurance company's scratching its head saying, how could this fender bender cause this serious injury? Well, the reason is that you were more vulnerable because you had a pre-existing condition. And so that can help your case. People worry so much about pre-existing conditions, but trust the lawyer to explain to you how it'll impact your own case, because often they help. In this case, the person's shoulder injury was different. It was a separated shoulder instead of a rotator cuff. It was 10 years ago, and so probably it's not going to have very much effect at all. What we would be looking at is figuring out, was this person living a normal life post hockey injury? So if we know that in the 5 years before the accident, the person's back to playing hockey and golfing, and we know he's riding a motorcycle, probably we're going to be able to show just on the facts that old remote injury has no impact on the torn rotator cuff, which, by the way, you can see with an MRI or an ultrasound. So there's no question that you have that torn rotator cuff.
Right. Interesting. Okay. Yeah, because I think a lot of people would assume maybe the opposite, that it could hurt you, but in fact, it could help along your case.
Yeah. Now, there are scenarios where somebody is still suffering from the injury. Like, let's say you had a concussion from, a sport, and then 3 months later, you're in a car accident and your concussion is exacerbated. Those cases are more difficult. Because we have to be able to prove where you were at on your recovery from the first concussion. So that can be more difficult, but not insurmountable. And, again, if you were recovering from a concussion and then get in a car accident, you're more vulnerable. So your outcome might be worse. So your recovery, when lawyers say recovery, they mean your compensation, might be higher. So don't make assumptions about pre-existing conditions. I guess that's the takeaway.
And then a good takeaway for both is contact a lawyer, because this is information you would not have otherwise known. You might make assumptions, and there's some things you can definitely get clarification for.